Welcome once again to our commerce classroom. In this session, we will discuss about consideration. The consideration is one of the essential elements of a valid contract. We know it. Consideration is one of the essential elements of a valid contract. We know it. The term consideration may be defined as the price of the promise. The term consideration may be defined as the price for the promise. The price for the promise. This term is used in the sense of quid pro quo. Quid pro quo, that is something in return. Quid pro quo means something in return. Section 2, subsection D of Indian Contract Act defines consideration as under: when at the desire of the promisor, the promisee or any other person has done or abstained from doing, does or abstains from doing, or promises to do or abstain from doing something. Such an act or abstinence or promise is called a consideration for the promise. I repeat, when at the desire of the promisor, the promisee or any other person has done or abstained from doing, does or abstains from doing, or promises to do or abstain from doing something. Such act or abstinence or promise is called a consideration for the promise. This is what the definition for consideration given by Indian Contract Act under this section 2 subsection D. Then we discuss about what are the essentials of a valid consideration. Essentials of a valid consideration. First essential element: consideration must move at the desire of the promisor. Consideration must move at the desire of the promisor. Consideration must be offered by the promisee or third party at the desire or request of the promisor. I repeat, consideration must be offered by the promisee or third party at the desire or request of the promisor. Second essential of valid consideration is this: consideration may move from the promisee or any other person. Consideration may move from the promisee or any other person. According to the definition, section 2 subsection D, when at the desire of the promisor, the promisee or any other person does something, such act is consideration. This thing is clearly stated in the definition. There can be a stranger to consideration, but not stranger to contract. I repeat, there can be a stranger to consideration, but not stranger to contract. Third essential: consideration may be past, present or future. Consideration may be past, present or future. In the definition, the words has done or abstained from doing, does or abstains from doing, or promises to do or to abstain from doing indicate that the consideration may be past, present or future. Past consideration: when the present promise is based on the consideration already taken place, that is before the date of the promise. I repeat, past consideration when the present promise is based on the consideration already taken place, that is before the date of promise. Then present consideration: when the promisor receives consideration simultaneously with his promise, it is termed as present consideration. I repeat, when the promisor receives consideration simultaneously with his promise, it is termed as present consideration. And the third one, future consideration. Future consideration. When the consideration for a promise is rendered in future, it is termed as future or executory consideration. I repeat, when the consideration for the promise is rendered in future, it is termed as future or executory consideration. Then fourth essential of a valid consideration is adequacy of consideration. Adequacy of consideration. Consideration need not be approximately equal value with the promise for which it is exchanged. I repeat, consideration need not be approximately equal value with the promise for which it is exchanged, but it must be something which the law would regard as having some value. But it must be something which the law would regard as having some value. The fifth essential of a valid consideration is consideration must not be unlawful, immoral, or opposed to public policy. Consideration must not be unlawful, immoral, or opposed to public policy. And the sixth essential of valid consideration is consideration must be real and not illusory. Consideration must be real and not illusory. Consideration must be real and be of some value in the eyes of law. Consideration must be real and be of some value in the eyes of law. Consideration of the following types are not real. First type, physical impossibility. Physical impossibility. A promise to do something which is physically impossible. A promise to do something which is physically impossible. Example, to make a dead man alive. To make a dead man alive. It is physically impossible. Second type, legal impossibility. Legal impossibility. If consideration consists of something illegal, the agreement will be void. We know it. Then third case, uncertain consideration. Uncertain consideration. An uncertain or vague consideration will make the agreement void. An uncertain or vague consideration will make agreement void. Another type of consideration which is considered not real, illusory consideration. Illusory consideration. It consists of a promise to do something which a person is already bound to do by law or contract. I repeat, in case of illusory consideration, it consists of a promise to do something which a person is already bound to do by law or contract. And the seventh essential of a valid consideration is consideration must be lawful. Consideration must be lawful. Section 23 of the Act says that every agreement of which the consideration is unlawful is void. Section 23 says that every agreement of which consideration is unlawful is void. It means that an agreement must be supported by lawful consideration. These are the essentials of a valid consideration. Then we discuss exceptions to the rule no consideration, no contract. Exceptions to the rule no consideration, no contract. An agreement without consideration is void. We know it. An agreement without consideration is void. We know it. But there are few exceptions to this rule. Few exceptions to this rule. First exception, agreement made on account of natural love and affection. Agreement made on account of natural love and affection. Section 25, subsection 1. This clause lays down 4 essential requirements for the validity of an agreement made without consideration. They are: the agreement must be in writing. Secondly, it is registered under the law. And then thirdly, it is made on account of natural love and affection. And lastly, fourthly, it is between parties standing in near relation to each other. These are the four essential requirements for getting this exemption under this point, agreements made on account of natural love and affection. Then our second exception to the rule no consideration, no contract is promise to compensate for past voluntary services. Promise to compensate for past voluntary services, section 25, subsection 2. Such promise made without consideration is valid if the act was done voluntarily for the promisor or something which the promisor was legally bound to do. The promisor must be in existence at the time when it was done, and the promisor must agree now to compensate the promise. Example, A finds B's purse and gives it to him. B promised to give ₹1,000 to A. This is a valid contract. Third exception, promise to pay time-barred debt, section 25, subsection 3. When a debtor makes a written and registered promise under signature of his own or that of his agent to pay a time-barred debt, no fresh consideration is needed. The following conditions must be satisfied for the application of this exception. First condition, the promise to pay must be definite and express. Second condition, the promise must be in writing. Third condition, the promise must be signed by the promisor or his authorized agent. Fourth condition, the debt must be time barred, that is, the limitation period for the recovery of the debt must be expired. Fourth exception to the rule no consideration, no contract, completed gift. Completed gift. The gift actually made by a donor and accepted by the donee are valid even without consideration. Thus, a completed gift needs no consideration. Then, fifth exception, contracts of agency. Contracts of agency, section 185. No consideration is necessary to create an agency. And the sixth exception, remission, section 63. Remission, section 63. No consideration is required for an agreement to receive less than what is actually due. These are the exceptions to the general rule no consideration, no contract. Then we discuss about privity of contract or stranger to a contract. Privity of contract or stranger to a contract. The term privity of contract means stranger to a contract. The term privity of contract means stranger to a contract. A stranger to a contract is not a party to the contract, so he cannot sue for carrying out the promise made by the parties to the contract. But this rule is subject to certain exceptions. First exception, in case of trust. When a trust is created, the beneficiary can enforce his rights given to him under the trust, even though he is not a party to the contract. Second exception, in case of marriage settlement, partition or other family arrangements, where a provision is made in the partition or family arrangements for the benefit of any member of the family, such a member can sue to enforce the agreement even though he is not a party to the agreement. Third exception, acknowledgement of payment. Acknowledgement of payment, where the promisor acknowledges payment to a third party either by conduct or otherwise, the latter can sue. Then fourth exception, in case of agency, a contract entered into by agent, the principal can sue on it. A contract entered into by an agent, the principal can sue on it. Fifth exception. In the case of assignment of rights under a contract in favor of a third party, the assignee can enforce the benefits of the contract. Sixth exception. Agreements relating to land. When any person purchases a land with the notice of rights and obligations of the owner, then he shall be bound by those rights and obligations, although he was not a party to the agreement. These are the 6 exceptions to the general rule. A stranger to a contract cannot sue for carrying out the promise made by parties to the contract. I think the topic consideration explained here is clear for all of you. We will meet again. Till then, goodbye.